Let's talk about McDonald's.
Yeah.
Shall we? John Rizvi, the patent professor, is here. Welcome to KFGO Radio.
Thank you. It's my pleasure.
Okay, so this whole beef that McDonald's has with this little hemp shop, I mean, what are they even worried about? I mean, Mick is something pretty common that a lot of people use. I think, I don't know, maybe we only know it as McDonald's, but it sounds like this hemp shop sells, among other things, smokable hemp flowers and CBD gummies. But one of America's most well-known corporate giants is trying to crush that application because they want McHemp. So what's going on here?
Yeah, so just a little bit of background on how the trademark process works. When somebody files for a trademark, and that's exactly what this small shop in North Carolina did. They filed for a trademark on McHemp. The trademark office provides a 30-day time period for anybody to oppose. You can think of kind of like at a wedding where the preacher says, if speak now or forever hold your peace. There's 30 days where if anybody believes they're going to be harmed by the trademark, they have an opportunity to oppose. And clearly McDonald's stepped forward and they said, no, we oppose. We think that this is going to negatively impact our brand. And you pointed out before about the Mick, like that there are other people that use MC in their mark. It's also, a common last name to have MC. But McDonald's issue is not just that consumers are going to be confused. I don't think they're worried about that somebody's going to think McDonald's is moving into the CBD industry. Their concern is that the wholesomeness of their brand is tarnished by being associated with this product. So they don't want to be associated with like hemp flowers or CBD gummies. And brands have a right to police that sort of thing, and that's what their opposition is based on.
So I guess, John, my question would be here is, does McDonald's have a leg to stand on for something like this? Is there a possibility that they will ultimately win out?
So I think they do have a really strong case. I mean, when you think about it, I mean, yes, there are others that use MC, but McDonald's has McChicken, McDouble, McCafe, McFlurry, McMuffin, McNugget. They have 13 different trademarks. And honestly, what's the first thing you think of when you hear of a product starting with Mc? So they have a really strong case that consumers are going to think of McDonald's, and they don't want them to think of McDonald's and in any way associated with hemp or marijuana or CBD or any of these products. So I think that's what's helping. If this was if this was a product unrelated, if it wasn't relating to drugs, I think McDonald's case would not be as strong.
So, like, for example, if I was trying to patent the Mick bicycle, right? They'd be less likely to go after it because they're like, oh, bicycle, we don't ever intend on getting into the bicycle game, so we're not going to challenge that one.
Yeah, so, well, McDonald's, I mean, they're just so litigious that I would bet they would challenge that as well. So there's a different basis. Like in that case, they don't have the tarnishment. Like there's no negative connotation to a bicycle. So their basis in that case would be that, hey, consumers think that we're somehow affiliated with manufacturing bicycles. And there's confusion there and the goodwill of our company's taken. But they don't have to rely on that. In this case, even if McHemp is able to show that, hey, that no customers really believe that we're associated with McDonald's, that's fine. That doesn't hurt McDonald's case because McDonald's is we're not basing our opposition on consumers being confused. We're basing our opposition on the value of our brand being negatively impacted.
Interesting. I was going to say, I mean, there's got to be other. Are they doing this a lot and we just don't always hear about it?
They absolutely are doing it a lot. Like if you, as a trademark attorney, as an intellectual property attorney, like if I would to do a search for opposition filed by McDonald's. There's hundreds and hundreds of oppositions. They never miss that 30-day window to oppose a trademark that they believe is going to negatively impact their brand.
Sure.
So this is very common.
Okay, so is the brand that could file against the one who all the pressure's on? So are they constantly every day having to go to like the patent website and read all the patents and determine whether or not each individual one might infringe on something that they have?
Yeah, you bring up a good point. Like, so what's the burden on companies that have a trademark? Like, there's hundreds of filings a day. Luckily in a free market system where there's a demand for something, some companies step forward. So there are services that will do this for companies, and they will charge a monitoring fee. And if they see any brands that they believe are potentially in conflict, they'll notify the company. And then McDonald's, of course, or whatever corporation there is, would have their in-house legal team evaluate which ones they want to oppose.
Oh, man. Okay, well, that sounds like not a job that I want. It sounds like just a lot of reading and clicking. And, but I find this incredibly fascinating, and I mean, this is one I'll follow. I'll check out how this is going. John Rizvi, the patent professor, has been with us. John, thank you so much for your time and shining a light so that we can understand the patent process a little bit better.
Perfect. Always a pleasure.